All right, everyone. Thank you for joining us tonight for Assemblymember Rebecca Seawright's Town Hall Tuesday. We will begin in just a few moments. And if you have any questions for our presenters, please feel free to put them into the chat and we will work to get the questions answered. If we do not answer your question tonight, we will work to get you an answer from our office as soon as we can. Again, thank you for joining us and we'll begin in just a few moments.
Good evening, and thank you for joining us for our 51st Town Hall Tuesday. I'm Assemblymember Rebecca Seawright, proudly serving the Upper East Side, Yorkville, and Roosevelt Island, hosting tonight from our state capital in Albany. We are currently facing a housing affordability and eviction crisis in New York State. The eviction moratorium ended 2 weeks ago, leaving tenants to rely on the funding from the Emergency Rental Assistance Program that we have established in Albany. Throughout the pandemic, we've held emergency sessions, voting on legislation to keep New Yorkers in their homes, extending the eviction moratorium, prioritizing federal funding to cover rental arrears, and homeowner and small landlord relief. We clearly can and must do more to protect financially distressed tenants with a replenished emergency rental protection program known as ERAP. I urged Governor Hochul for the extension of the eviction moratorium and to our federal representatives to request additional federal funding to be released for the ERAP program. $1.6 billion in additional to funding has been requested by our governor to be able to continue fulfilling those requests for relief. Even with tenants filing for ERAP and hardship declarations, 600,000 people are currently behind on their rent. Landlords filed for more than 100,000 eviction filings throughout the state. Rates of eviction filings being higher, nearly twice as many against tenants in areas where predominantly people of color reside. In the Assembly, I'm proud to co-sponsor and strongly support good cause eviction to prevent illegal harassment and unfair rent hikes, and the Housing Access Voucher Program to help those who are at risk of eviction. We are encouraging tenants to apply for the Emergency Rental Assistance Program, which has reopened to prevent evictions until their requests for relief are fulfilled by the federal government. We also encourage co-op and condo owners to apply for the Homeowners Assistance Fund if you've experienced a loss in income as a result of the COVID-19 pandemic. We will hear more on the issue facing tenants and homeowners, the Assistance Fund, with our guest speakers this evening. We have a great program lined up for our town hall. Noelle F. Eberts is a supervising attorney in the Consumer Protection Unit at the New York Legal Assistance Group. She came to this position as a staff attorney in the Foreclosure Prevention Project in 2014 after practicing at a mid-sized law firm representing parties in real estate transactions. She represents homeowners in foreclosure proceedings and related affirmative litigation, and is an active member of New Yorkers for Responsible Lending Mortgage Subcommittee and the New York City Bar Mortgage Task Force. She earned her JD from Brooklyn Law School in 2011 and her BA from New York University in 2006. Welcome, Noelle.
Thank you for the warm welcome, Assemblymember Seawright, and thank you so much for having me. As you mentioned, this is a very trying time for New York City residents and the state and the nation.
We're going to go on to a few questions from our viewers. Homeowners Assistance Fund cover, and will it cover co-op and condo fees?
Yes. So first, absolutely, condominium common charges and cooperative maintenance fees are absolutely eligible arrears that the program is intended to assist homeowners with. Do you want me to go through the details, or I have a slide? How would you?
Our office is continuing to host a pro bono housing clinic. And our next speaker comes to us. We're working out a little technology glitch with Noelle, but I do want to go ahead and introduce our next speaker, someone that I greatly admire and deeply appreciate his service to the people of my 76th Assembly District. Robert Grimble has been practicing law in New York City since 1976. He earned his Bachelor of Science from Massachusetts Institute of Technology, MIT, in 1972, and he went on to earn his law degree from Northeastern University in 1975. After serving as a clerk to the Honorable Eugene Nordelli, Bob went into private practice in 1981. Bob believes in giving back to the community. He has worked for many years as a volunteer at Eviction Intervention Services and Project Basement, and in 2003 was awarded the prestigious Jane Brown Service Award. He has generously provided no-cost legal housing advice to hundreds of constituents at our Tuesday clinic. Welcome, Bob. It's great to see you this evening, and thank you for all of your expertise on this important topic. We have some questions that have come in for Bob from our viewers. Now that the eviction moratorium has passed, what can tenants do to ensure that they have a fair case if their landlord begins eviction proceedings for non-payment?
Well, first of all, you have to realize that right now the courts are very backed up with cases. And while there is no moratorium in effect after January 15th, in effect, cases will take their time. You also have to consider that housing court judges are rather sympathetic and understand the problems. And even in good times, if someone is behind on their rent or their co-op maintenance, they can usually work a payout schedule for payments of arrears. So as long as people are aware of their rights and put up some sort of resistance, they will have an opportunity to delay matters somewhat until funding can come through, and so on. And in terms of fairness, I mean, the courts are really pretty fair. I mean, the housing courts in New York are so much better than, and when I go to other parts of the country and I see what goes on in terms of housing, it's like appalling. New York City is much better. New York State is much better, thanks to the legislature, thanks to our judiciary. So in terms of fairness, there's not too much of a problem, but it's understood that people need to arrange payouts. They need to arrange delays. Right now, there's a major program going on to get legal services hooked up with tenants who are self-represented, and they can aid greatly in working out payout arrangements.
Right, wonderful. I'm just so pleased to have you on the show tonight, Bob, so that we can address some of these questions that have come in from constituents. And it looks like we've worked out our technology glitch, so we'll be coming to you, Norelle, shortly. But Bob, can you tell us about the hardship declaration form and how it will protect tenants?
Well, originally the hardship declaration form provided a means for tenants to notify landlords in the court that they had suffered a hardship due to the COVID epidemic. That tied in with the moratorium that expired on January 15th. So at this point, I mean, while it is possible to get further relief in the court system if you have a pending ERAP, the hardship declaration itself was initially geared to the stay of proceedings. And while that stay was in effect, if somebody had filed a hardship declaration, the case was put on hold. And this happened to a large proportion of all housing court cases, which is why the courts are backed up with literally hundreds of thousands of cases.
I see. What is the most common thing that you're hearing from constituents and homeowners and rental constituents that are suffering? What is the single most issue that comes across your plate as an attorney?
I would say that a very large proportion of it have to do with people who just don't have the money for whatever reason, because their income has been adversely affected by COVID. Their living expenses may have increased due to COVID. That's another factor that people have to take into account. I have a number of clients where a family member has been hospitalized due to COVID. So I would say the lack of money is a major problem. And as I say, the one good thing about it is generally possible to work out payout arrangements, delays. And that's true even in the absence of a pandemic. But in the pandemic situation, it's much, much easier if people really need it.
Right. And, our office has a dedicated staff person to help with unemployment claims for people that are needing or having trouble with that state agency. So are people that are protected, that have applied for the ERAP program, but have not necessarily received the funds yet? Or do they have protection? And what is their right? Go ahead.
My understanding is that they do have protection. And I think also, as a practical matter, even prior to the pandemic, if somebody had an application in for assistance, a one-shot deal, for example, they would have an opportunity to pursue this. So I think as a practical matter, even if there is a lapse in the program for some period of time, and there may not be a legal stay, although as I understand it, courts are staying proceedings where there is a pending ERAP application if the issue is money. It doesn't apply to nuisance cases where somebody is causing a real problem in the building, but they can obtain a stay because of that. And again, I think most judges are cognizant of the fact that we have this situation, and if the money is coming or a portion of the money is coming through ERAP, that's okay. The one problem that I have come up with, I have come across situations where landlords refuse to deal with ERAP, which is a great problem. And it's sort of like, why do you have to force them to take money? But that is the problem, and I hope that maybe the legislature can address that situation. Perhaps a rent waiver if the landlord refuses to accept their ERAP benefits.
Sounds good to me. Something that I'll certainly push for. And what is the right to counsel of tenants?
Well, the right to counsel in any civil matter, it's like, yeah, you have a right to have an attorney, but the court doesn't have to appoint one for you. Now, that is, I think, gradually changing, but we're talking about decades of growth. And keep in mind that people talk about, in a criminal case, people have the right to have an attorney appointed for them to defend them in a criminal case. But this really wasn't even clear under state law until the middle of the last century, the 1960s. At this point, and in New York, we have situations where there are a number of legal services organizations. We have a situation now where we're conferencing cases with judges using Teams, which is basically very much like Zoom. And somebody from, say, Northern Manhattan Legal Services, one of the legal services organizations, will be on the conference to speak to the pro se tenants and arrange an intake. So while there's no statutory right to have counsel appointed. The court system and the legal services organizations are working very hard to try to give some legal advice and some legal representation. That being said, the legal services organizations are buried. They are grossly overworked and grossly underfunded.
Mhm. Well, we will certainly, as we negotiate the state budget, try to do more to fund our CBO, community-based organizations and advocacy and legal nonprofits that are helping our tenants. How can tenants organize to address building-wide issues? What's the best advice that you could give for tenants wanting to organize in their building?
That's actually a very interesting question, and it's also, I mean, there's some cultural issues involved here. When I started representing tenants, I was representing a lot of tenants on the Upper West Side, and it was like sort of at the tail end of some very strong labor movements. And those buildings were very easy to organize. The tenants were organized. They had a belief in their neighborhood, a belief in the strength of organizing together. We have less of that now, but the way to organize your building is to go do it. Go knock on doors. You have the right to have meetings in the lobby of your building. You can, in fact, it was an assemblyman's aide was at one point arrested many years ago, decades ago, for organizing a tenant meeting in the lobby. And the legislature then passed a statute that says that, yes, tenants have a right to have a tenants association meeting in the lobby of their building or any other public area of the building. Talk to your neighbors. Walk around, put leaflets under the door, be out there and talk to people. The organization is largely an attitude. Organization is working with people, being willing to tell the other people your concerns and listening to their concerns and realizing that you have a lot more strength together. And this is one of the things that I remember when I was first starting to work here, that the tenant organizers would always be saying, hey, we've got a lawyer here, everything's going great. And I would look at it and I say, we have a tenant organization here. Everything's going great. We have a good leadership. We have a rent strike going. They have their tenant association escrow funds. They're together. They've gotten all their repair lists together. They've identified the issues in the building. They've done a lot of the legwork. They're willing to come to meetings and so on. So the best way to organize is to organize.
Mm-hmm. And terrific. And I want to encourage everybody to do that. We keep in our storefront office a framed t-shirt that says the landlord is not the law. So where should tenants report tenant harassment, such as landlords withholding lease renewals?
Okay. Interesting issue because it's, there's different kinds of harassment. Some of it is so petty that as long as the tenants don't let it get to them, it has no effect. And a lot of that is like, verbal, not abusive language, but just, yeah, you should really move out of here. With different kind of buildings, not like when you moved in. That kind of stuff, you really can't do an awful lot about. If a landlord's not renewing the lease, if you're a rent stabilized tenant, you do have the right to go to the DHCR, although the DHCR is not my favorite agency. The DHCR is incredible. They administer rent regulation, rent stabilization, and rent control. And they have a form you can fill out if the landlord has refused to renew your lease. You can file a complaint. However, last time I spoke to people in their counsel's office, they were saying it took 18 months to get a docket number assigned on the cases. Typically, if the issue is refusal to renew a lease, and if you're a rent stabilized tenant, the landlord cannot just arbitrarily refuse to renew your lease. There are a few very, very specific grounds. The major one is that it's not the tenant's primary residence, that the tenant doesn't live there. If it's a rent stabilized apartment, you really have to live there to keep it. People run into problems sometimes when their accountants tell them, oh, you've got a summer house out in the Hamptons, register the car there, pay your taxes there because the taxes are lower. Really stupid. Don't do that. Okay. If you live in New York, pay your taxes in New York. You live here, you vote here, et cetera, et cetera. So But there are other types of harassment as well. Refusal to give services. And a lot of times this is not an outright refusal. It's a foot dragging. It's, oh, John the super knocked on your door yesterday at 2 o'clock, but you weren't there. And, oh, we have to go out and get parts, et cetera, et cetera. People should not dilly-dally around in terms of when landlord won't do repairs. Call 311. If the landlord doesn't come in and show all signs of voluntarily correcting what needs to be corrected, and they want to harass you, they figure you have a cheap rent, and so you're going to get cheap services, well, you're entitled to have your apartment in good and proper repair. That's different from it being a luxury suite, but you're entitled to proper repairs. You don't have proper repairs, and withholding proper repairs is a major form of harassment. Call 311. You can also litigate in court over a number of forms of harassment, including some of the forms that are like serious verbal abuse. And this happens a lot more than you would think. People are concerned that they're going to get beaten up and so on. I don't see that very often, but I see an awful lot of cases where there is profanity, somebody blocking somebody getting on the elevator, nasty remarks when they walk by, ethnic slurs, et cetera, et cetera. There is an action under the Housing and Maintenance Code, and the legislature, as part of the HSTPA in 2019, enhanced the remedies against that type of harassment or anything that you could just call harassment. Unfortunately, judges hate harassment. I've had brought it up in many cases, and I would say in a lot of them, judges just say, oh, no, we're not going to handle that. We're not going to touch that. And that is sort of the thing that I don't know what you do about that. You can lay it out in front of the judge. Is it worth somebody's while to appeal it under those circumstances? Probably not. And again, the legislature might address something like that. Giving a tenant a monetary remedy if they're harassed might actually be very beneficial. I don't know whether that would pass in the legislature or not. There's a real problem with identifying what constitutes harassment. And that is something that has to be dealt with. A lot of times it's something that falls into some other category: refusal to do repairs, ethnic slurs, discrimination based upon race, religion, sexual preference, and so on.
So what should tenants do if the building has no heat or hot water during the winter months?
First thing you do is you call the landlord, wait, see what they have to say, and then call 311, and don't delay in calling 311. Call 311 like immediately if the landlord doesn't send somebody over to turn on the boiler. Another situation that may come about is that the heat goes off, but like only between 9 o'clock and midnight or something like that. Under those circumstances, tenants should keep a temperature log. They should stick a thermometer someplace in the middle of the apartment, not over a radiator, but you don't scotch tape it to the window either. And take a calendar or a notebook or whatever and put down the time and the temperature reading, and keep that as it's called past recollection recorded in the court system, but that is then admissible as evidence to show what the temperature was if you wind up getting in a court case. And if you don't have heat and hot water, you're entitled to an abatement of rent. It depends on how severe it is. I would say typically 50% abatement for any period without heat and hot water is pretty typical of what judges will do. If the heat and hot water are out for 2 hours, they probably wouldn't do anything. If the heat and hot water are out continuously for a week or two, they would probably do more. But that's sort of a guideline. You're entitled to get, and again, this is much the same procedure as for any repair issue. Tell the landlord, give them a reasonable opportunity, and if it's an emergency or lack of heat and hot water or a flood, not very long, call 311. If it's something that poses an immediate danger to the building, burst pipe, call 911. The fire department will get there and turn off the water if there's a broken pipe or whatever.
Wonderful. Well, that is excellent advice for our viewers. I have one final question. If a tenant reports a violation to the city, is management allowed to charge that cost of the violation to the tenant?
What's strange is that somebody asked me this very question, and it was in a co-op situation, which is unusual. A rental tenant, the answer is absolutely no. In a multiple dwelling, that is the building with 3 or more apartments, the landlord has a duty and an obligation to keep the building in good and proper repair and free of violations. In a cooperative situation, you typically have something where the tenant, the proprietary lessee, the apartment owner, has the obligation to make certain repairs in the apartment, and the co-op corporation, the fee owner, they're the people on the deed, things like pipes, risers, basic electrical systems. Now, both of those people have a legal obligation to make sure that the premises are in proper repair. Financially, if the proprietary lessee, the apartment owner, has signed a lease that says that they're responsible, say, for keeping the kitchen faucet from dripping, if there's a violation, conceivably the co-op could bill the co-op owner for the cost of the violation and for the cost of repairs. It's actually not unusual where there's a proprietary lease where the owner is responsible for the inside of the apartment, that the co-op corporation will do the repair and then bill the proprietary lessee. But you have to separate out the legal obligation to pay for something and the legal obligation to keep an apartment in good repair. If you were, say, a rent-regulated tenant in an apartment, a sponsor apartment in a building that's gone co-op, and the sponsor, the owner of your apartment, is saying, oh, I don't have to fix that, that's the co-op. And the co-op says, no, we don't have to fix that. That is the owner responsibility. Well, the fact is, in terms of getting the repair, they are both equally liable. You should go and fight to get the repair, and the owner of the apartment and the co-op can figure out between themselves who has to pay for it. That's not your problem. If you're a rental tenant, even a rental tenant in a co-op apartment, you are not responsible for making those repairs or paying for those repairs. I hope.
Wonderful. Well, thank you. Yes, excellent. Thank you. Thank you very much, Bob. You've been such a true community activist and lawyer with your expertise, and we can't thank you enough for coming on the show tonight and to continuing to service pro bono constituents of the 76. We really deeply appreciate it. So thank you. Next, we're going to go back to Noelle. Our glitch with IT has been straightened out. So I previously introduced her, and I would like to now go to some questions with our time left. What does the Homeowners Assistance Fund cover, and will it cover co-op and condo fees? And welcome, Noelle.
Thank you for the warm welcome earlier, and I'm really happy to be here. So the Homeowner Assistance Fund, I'm going to refer to it as HAF for this conversation. It covers any housing expense, and that includes common charges for condominium owners. It also includes maintenance fees in the cooperative buildings. And the other great thing is that it includes mortgage arrears. And also, we've been seeing a lot of homeowners who've been experiencing assessments throughout the pandemic. And, for those homeowners, they may have a seemingly modest, common charge, and suddenly they're hit with a $2,000 assessment that they simply can't afford. And now they're struggling and it's ballooning into bigger problems. So for those homeowners, the assessments are included, the common charges, maintenance, and mortgage arrears.
Great. And what should a person do if their co-op board doesn't approve their request for homeowner assistance funding?
Sure. So the Homeowner Assistance Fund application doesn't formally require any board approval. So, typically the homeowner can apply on their own. They can submit the application either online or by calling. And as long as they meet the basic eligibility requirements and they can prove their arrears, which is simply sending in your monthly statement, right? Showing that you're 3 months behind on your common charges, or showing you're, a couple months behind on the maintenance fees. As long as you have that documentation, HAF is just going to send a check, assuming you're approved, to your board directly or to your management company.
So if your income is lost, as an individual, is that enough to qualify for this forward payment program?
So the critical moment in time to determine if you're eligible for HAF is January 21st, 2020. So as we all know, the brunt of the pandemic hit us in March 2020, but the HAF program looks back to January 21st. And if you suffered a financial loss of income, or if you suffered any increased out-of-pocket expenses directly related to the pandemic, you're eligible for HAF. So basically, any homeowner who's struggling to make their housing payments because they've lost income due to the pandemic, or because they've had increased medical expenses, or they had a huge insurance premium or copay that they couldn't handle, anything like that that's directly related to the pandemic, you're going to be eligible for the HAF funds.
Okay, great. And when and how will the funds be distributed? And are applicants that are currently in foreclosure given priority?
So the funds are being distributed first come, first served. So the critical thing to know is that the assistance program started accepting applications on January 3rd. So right now, the first people to apply, presumably their funds are going to be distributed first. And there are limited funds right now. And those funds will be distributed directly to the boards or directly to your mortgage companies.
Will this cover arrears prior to the pandemic that occurred?
So the program can cover the arrears that are prior to the pandemic. The critical question is really going to be if, for example, you were unemployed in December 2019, and then the pandemic hit in March 2020, and you were unemployed during the pandemic, then you would qualify for the HAF funds. And that loss of income would then allow you to use the HAF funds to cover that December, mortgage payment, if that's the payment that you need assistance with.
Okay, great. And can one still apply if they are receiving a mortgage modification from a financial institution?
You can absolutely still apply. However, timing is critical, because in addition to being behind on one of your housing payments, you have to be behind for at least 30 days. So if you've recently accepted a mortgage modification and you're deemed current on your mortgage, you would not be eligible for HAF funds. However, I've spoken with a lot of homeowners who are just starting to get back on their feet and who are just coming out of a forbearance, for example. So they're just being expected to resume these payments, and they're being offered modifications, but the modified payments are still unaffordable. So for those people, if your modified payment is deemed unaffordable, you may still qualify for HAF funds. And the magic number is 35% of your monthly income is really what they're going to determine the affordability.
Mm-hmm. That's good to know. Can co-op shareholders apply for HAF if they've applied for the HRA one-shot deal?
So again, if they've applied for one shot and they received funds and things are going well, then they wouldn't be eligible. But if they have an application pending and they don't know if they're going to be approved or not, I would absolutely 100% say apply for HAF. If one shot works out faster, then so be it, and you withdraw your HAF application, because again, time is of the essence. And I would hate for someone to not apply for HAF and then not receive the one shot and find out that HAF is out of money at that point.
And are Mitchell-Lama co-ops eligible for HAF?
Absolutely, yes. Mitchell-Lama is intended for, low to moderate income New Yorkers, and the HAF program is absolutely intended for those same individuals.
Well, that's very good to know. So on Roosevelt Island, which is also in my district, we recently had a conversion from Mitchell-Lama in the Westview building. And yesterday I questioned the DHCR commissioner about issues that had arisen on succession rights with my constituents. So housing is such an important topic, and I think housing, affordable housing and COVID are the #1 issues facing the 76th Assembly District today. And so, Noelle, I just want to thank you for joining us this evening and sharing your expertise. And do you have any parting words for our viewers tonight?
Absolutely. I think first and foremost, if you have any questions about the HAF program, absolutely ask, whether it be reaching out to your assembly member and she can put us in touch with the right people, or NILAG directly. The other thing to recognize is the HAF program has a fabulous website. When I have a question about the program, the first place I look is the HAF website, and I can share those materials if you like. But it's NewYorkHomeownerFund.org. There's also a phone number available, 1-844-77-NEW-YORK-HAF. And those are really great resources to see, do I qualify? How long does the process take? How much money can I receive? Any questions that you have, definitely reach out for assistance. Also, there is a statewide network of agencies similar to NILAG that are part of the Homeowner Protection Program, HOP. And there are many individuals in New York State, just like myself, who have been trained on the HAF program and are willing and able to assist you if you have any questions or if you need help actually applying for the HAF funds.
Great, terrific. And we appreciate your repeating that information, and we'll also reinforce it in our news blast and in the chat. And Bob, do you have some parting words for our viewers this evening? Is Bob unmuted?
Not yet.
I see I was muted. Well, all I can say is, hang in there. All right. There are an awful lot of people who I think are very discouraged by the pandemic and so on. Yet we have a legislature the New York legislature's done a lot to help people get through these situations. Homeowners, rental tenants, businesses, and so on. This is something we can get through. And I believe that judges, the courts, everybody is willing to work to maintain the best system we have in New York. And I think, one of the issues, again, in this neighborhood is neighborhood stability. And that is always something that's been of a concern for me, that succession rights and so on, that you want families to be able to stay in the same neighborhood. That is, an important thing, and we don't like to see people driven out of their neighborhood so somebody can make $1 zillion putting up a building. And this time when people are feeling financial pressures, don't panic. Okay, there may be financial pressures on you if you work, if you talk to people, if you understand that the courts, the legislature, and so on are extending a hand to help you get through this. You don't have to move your family out of the neighborhood where you've grown up and maybe been here for a few generations. And it may be that there are developers who really would like to have your building empty, you out. Hang in there. That's all I can tell you.
All right, hang in there and contact your local legislator. I'm Rebecca Seawright, your assembly member, honored to serve the Upper East Side, Yorkville and Roosevelt Island, and we will put you in our free housing clinic with Bob, and also reinforce the contact information for Noelle. So thank you for joining us both, Noelle and Bob, and sharing your expertise this evening. And thank you to our viewers for tuning in to our 51st Town Hall Tuesday. I also want to give a shout out to my staff and invite you all to stop in our storefront office. We're located between 78th and 79th Street on York Avenue, right near the post office behind the bus shelter. If you need more information on the programs that we discussed tonight, please don't hesitate to reach out to us at 212-288-4607 or by email at cwriter@nyassembly.gov. Or you can visit the district office, again, at 1485 York Avenue between 78th and 79th Street. I invite you all to tune in later tonight to watch Rise Up with Rebecca Seawright on the importance of mentoring with our special guest, Susan Taylor, founder and CEO of the National Cares Network. That'll be aired at 8 p.m. On Manhattan Neighborhood Network, Spectrum 34 and 1995. Stop by our office every Thursday on a weekly basis from 12 to 2 for our no-cost PPE and home test kit giveaway. I ask you all to stay safe, get vaccinated, get boosted, be well, and if we can be of a service, please give us a call. Thank you.
Thank you, Assembly Member. Have a good night.